Hello, welcome to Quimbee CLE. My name is Jillian and I'm a program attorney here at Quimbee. Today I'm joined by Larry Coonan, who will be speaking with us about current issues in technology law that lawyers are facing today. Larry is a partner at Morris, Manning & Martin and serves as chair of the firm's technology and intellectual property litigation practice. His practice focuses in commercial, technology, and intellectual property litigation and consultation, and Larry's clients have ranged from publicly traded companies to startups and individuals. We are so excited to have you here with us today. Welcome, Larry.
My pleasure.
All right, so why don't we just start off today, Larry, if you want to just give us an overview of kind of what we'll be talking about.
Sure. We're going to be talking about two high-level technology topics today that are critical for attorneys' current practice. And this is especially in the area of either litigation or data security. The first subtopic we're going to cover are EDiscovery issues, electronic discovery issues, along with attorney ethical duties that go along with that. And then the second part will have to do with data security. We hear, every day about data breaches occurring in our world, and about how in the attorney's practice, there are actually ethical rules that make attorneys' obligations related to data security even higher than that of the public. And we're going to be talking about what are those rules and the reasons why an attorney needs to pay attention to their own data security.
Okay, great. So let's just start off with that first section you mentioned, EDiscovery. So Larry, why is EDiscovery so important?
Simply, our world has changed from a paper world to an electronic world. So when we get into litigation specifically, litigation is all about evidence. Evidence in all forms is now stored electronically. It could be everything from an electronic photograph of a car accident to communications in a corporate deal. It could be telephone recordings, text messages, you name it. And now it's even complicated by the fact that we exist in the cloud. We have social media. People communicate on social media. People say things on social media that are important. Those are stored on the cloud. And sometimes people are not aware that when they talk on social media, they're actually creating a record that could be evidence in a lawsuit. Just as one simple example, when I take a deposition of somebody, I usually prepare by actually going to their social media, if they have one that's public, and see what their biases might be or what they might be saying, possibly even about the case. But more importantly, because that information is usually anecdotal, it's finding the evidence, who said what to whom in an email. And so when we get into lawsuits, unlike the old days where we were going into file cabinets and pulling out letters and reviewing those letters, everything is now electronic. And that's good and bad, because it creates an easier way to search through information, because you could do search terms, for example, or you could electronically search for a file location as opposed to going into a warehouse. At the other side of the coin is it's very, very large. And sometimes unwieldy volume. And I'm going to give one example that I tell people. You send an innocuous email to somebody. That's just one email. And I send it from my iPhone. Well, that email's on my iPhone. Then it goes up to the Apple server. And then from the Apple server, it gets shifted over to whoever is the internet service provider for my law firm, which then downloads the email to my law firm into its Microsoft Exchange. I've already created 4, 5, maybe 6 copies of a single email just by sending a one-sentence email to one person. Now imagine that person replies and copies 2 people. And then 2 of those people reply to that. Next thing you know, a one-line email has 40, 50, 60 copies to it. So it's a tremendous volume, and we need to learn how to get through that volume, and there are tools to do that, and we'll talk about some of that today. Another reason why electronic discovery is important is because if you don't do it right, then your client and yourself potentially could be in trouble with the court and even get sanctioned by the court, because if you fail to gather the appropriate evidence or preserve the evidence, and we'll talk a little bit about preservation later, but if you fail to do that, you are technically impeding the opposing party's ability to prove their case. And so as a result, the court may actually sanction you.
And Larry, can you give us an example or a few examples of the kinds of things that can happen when attorneys are not paying attention, especially regarding sanctions?
Yes, and I'm going to give you some example case law. And this case law, I'll say at its high level, is meant to scare you, and it's meant to scare you into making sure you do the right thing. But I will say that sanctions themselves are usually pretty rare. Here's why I say that. Let's say I have some emails I exchange with somebody, and I, with intent, destroy those emails.